All right, it's Ashley again, private online tutor, day-to-day social work. I specialize in assisting people to pass a license exam in social work on the master's and bachelor's level. I can be found online at daytodaysocialwork.wix.com/my site, and I can also be found on YouTube at Day to Day Social Work. I offer tutoring. You can find that information on the website, and you can also, if you would, like, subscribe, and share the channel with your friends. Now I'm going to jump back in on the rest of these revisions to the Code of Ethics that will take place on January 1st, 2018. Again, this is not to discount what we already have learned about the Code of Ethics. This is just in addition to, and this is a revision and amendments to what we already know. So please continue to study the Code of Ethics as it is, but just be open to this new information. And again, bear with me because I have my braces in. So this whole video will be dedicated to one section because it is so lengthy. And this is the privacy and confidentiality section. So these are some amendments. So this is going to be one of the most important videos because these are things that are changed, and I'm going to take my time with this one because I haven't read it all the way through yet, so I want to make sure that we're good. So privacy and confidentiality 1.07, standard 1.07a was amended to state that social workers should not solicit information from or about clients except for compelling professional reasons. The term compelling professional reasons replaces essential to providing services or conducting social work evaluation or research. The new language is more concise. The new language also focuses the worker on professional considerations rather than just what the worker believes is essential. So we should not solicit information from or about clients except for compelling professional reasons. Okay, so if it's not dealing with professionalism or what we're there to help them with, we should not be soliciting that information. And then it says standard 1.07c was amended by removing the term identifiable person. Under the revision or the revised version of this section, an exception of confidentiality arises when disclosure of confidential information is necessary to prevent serious, foreseeable, and imminent harm to a client or others. Note that this section permits social workers to disclose confidential information under certain circumstances. It does not require them to do so. The removal of identifiable person is important for situations such as threats of terrorism, school shootings, or other violence in which the risk is serious, imminent, and foreseeable, even though the worker cannot specifically identify the individuals or groups at risk. In some jurisdictions, mandatory reporting laws require social workers to report information or take other steps to address particular risks of harm, even though the social worker cannot identify a particular group of people that are at risk. This revision ensures that the social worker is ethically permitted to follow such laws and reflects changes in many states' laws, such as NASW adopted current Code of Ethics. So that's a lot. So they removed the term identifiable person, and that's important. So make sure you compare, because that's an amendment. So you need to make sure you look back at privacy and confidentiality 1.07, that section, and that standard C. Make sure you look at what it is now in 2017 and compare it to what the revision will be in January 2018. And I don't have it in front of me, so I can't say, but make sure that you do that. All right. Then it says standard 1.07F was amended to state that when social workers provide counseling to families, couples, or groups, their agreement with the party should include consideration of whether confidential information may be exchanged in person or electronically among clients or with others outside of the formal counseling session. Such an agreement would address questions such as whether the clients agree that information may be shared electronically by the social worker, for example, through email, as well as whether the clients want any restrictions on the sharing of confidential information among family or group members, for example, an agreement not to discuss group information on social media. So this is an agreement within the group or within where you have more than one person. You're discussing this with them to make sure that they're okay with. It's kind of like what happens in the group stays in the group. And so if everybody needs to agree that, we're not going to share this on social media, or we can, or we're not going to mention this outside of the group, or we can, or, I don't want the social worker telling somebody else this through email. So make sure you read through this again and make sure you get a good understanding of that. But it states that when the social worker provides counseling to families, couples, or groups, their agreement with the party should include consideration of whether confidential information may be exchanged in person or electronically among clients or with others outside of the formal counseling sessions. So, now standard 1.07I was amended to clarify that social workers should not discuss confidential information electronically or in person unless confidentiality can be ensured. So they want to clarify that. So you cannot discuss confidential information electronically or in person unless confidentiality can be ensured. So, don't go emailing or talking to people in person unless you know for sure that this information is going to be kept confidential. Let's see. One of the most outdated standards of the 2008 code was 1.07M, which referred to fax machines, answering machines, and telephones as examples of technology. The standard instructed social workers to avoid disclosing confidential information when using such technology. This standard was first adopted in 1996, long before social workers were using online video conferencing, smartphones, text messages, social robots, remote electronic storage of client records, online social networking, and other forms of technology. Today, transmitting identifying information through technology is not only pervasive, but required for many purposes. The new version of 1.07M permits transmission of identifying information, but advises social workers to take reasonable steps to protect the confidentiality of electronic communications, including information provided to clients or third parties. To protect client confidentiality, social workers should use applicable safeguards such as encryption, firewalls, passwords, all that stuff. As technology changes, social workers need to keep up to date on which methods are most appropriate ways to protect client confidentiality. Then it says a new standard, 1.07N, advises social workers to develop and disclose policies and procedures for notifying clients of any breach of confidential information in a timely manner. So we need to come up with policies and procedures to notify our clients if we happen to breach confidentiality accidentally, on purpose, any kind of way. We need to develop policies and procedures that tell us how we need to do that, and that we need to do it in a timely manner. Some social workers and social work agencies are required by law to notify clients of any breach of confidential information. So this new standard alerts social workers to this issue. And so that's kind of common sense too, though. Like, of course, we have to tell our client that their information was leaked by accident or unintentionally. So a new standard, 1.070, builds on 1.07N by advising social workers to inform clients of unauthorized access to the social worker's electronic communication or storage systems consistent with other laws and applicable standards. Disclosure of such breaches permits clients to take steps to protect themselves from identity theft or other possible consequences of the breach. So if you happen to be transmitting files for your clients from one office building to the next, and somebody breaks into your car and steals your briefcase with the files in it, and they had your client's social security numbers and all that stuff on it, we need to let our clients know. And like this says, inform clients of unauthorized access to our electronic communication or storage system. So if it was your laptop and you had it on sleep and your password was password 123, which should never be your password because it's too easy to guess, but somebody guessed it and they got into your computer and saw all your clients' files, that's what they're talking about here. And then it says a new standard 1.07P advises social workers to develop and inform clients about their policies on the use of electronic technology to gather information about clients. This section is intended to make social workers aware of client privacy issues, particularly when considering whether to gather client information electronically. And then a new standard 1.07Q builds on 1.07P by discouraging social workers from searching or gathering client information electronically unless there are compelling professional reasons and, when appropriate, with the client's informed consent. For instance, a social worker may need to gather information electronically to protect the life or safety of the client or another person. Whenever possible, the client's consent should be requested in advance of search for client information. Then we got two more. So a new standard 1.07R states that social workers should avoid posting any identifying or confidential information about clients on professional websites or other forms of social media. Although clients may consent to having identifying information posted on the social worker's social media, the social worker should ensure that client consent is fully informed. So if your client has a success story and you want to show them off because you've worked with them for 8 months and now you finally help them get a new home and they're in a new job, they finished their degree and you want to show them off, you have to make sure that you get full consent from that client before posting them on your Facebook, on your Instagram, and all that kind of stuff. So make sure that you have full informed consent. Even if the client has said yes, you can, you still cover yourself and make sure you have consent from the client. Let's see. Consider, for instance, a client who offers to post a positive comment on a social worker's website attesting to the great addictions counseling she received. The client may not realize how future employers or others may have access to this information, or how it may be safer to post a comment without identifying information. So that's true too. So, the client's been going to addictions counseling, and then somebody that may be about to hire that client looks on your information or your professional website and sees that that client has gone to addictions counseling. That might not be a good light for that client, and it could cause some bias by that employer and could possibly prevent the employer from hiring your client. So then standard 1.07S, which is the last one on this video, says contains a small change in language from the original standard, replacing state statutes with applicable laws. When considering how to transfer or dispose of records, social workers may need to consider state and federal statutes as well as case law. The new language covers all forms of applicable laws. So not only your state statutes, but just any applicable law, whether it's federal, state, case law, all that kind of stuff. Okay, so that's it for this video. I'll be back with another one. See you soon.